the PSR follows your client for the rest of their lives, potentially, because if there are any future arrests or prosecutions, they're probably going to ask for this report, so you want to make sure it's correct. Designations are based on it. Programming is based on it. Sometimes it affects visitation at the BOP. It has to be correct.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. I am so giddy about today's guest. And I'm just gonna jump right into this because we have so much to talk about. But I want to welcome to Set for Sentencing, Leslie Lockwood. Hi, Leslie. How are you?
Hi, good. How are you?
All right. So this is what's so cool about having Leslie on the podcast. Leslie's a mitigation expert, and I've had mitigation experts on the podcast, so that's not a first. But what is a first is that in Leslie's former life, she was a United States probation officer who worked almost or totally exclusively, correct me if I'm wrong, in the pre-sentence division, which means
Totally.
yeah, so she's retired there. She spent, I think she started in 1992 with the probation office, retired in what, 2016?
Correct.
Yes, and for many of those years, she was a supervisor in the pre-sentence investigation division, which means she supervised investigating probation officers, writing the pre-sentence reports, making recommendations to the court, and the whole 9 yards. And so when she retired from U.S. probation, she took that skill set, that expertise. She's a master's in social work, that whole background, and put it to use in the field of mitigation. So she's a mitigation expert. But what we're really talking about today is the pre-sentence stuff, because I've been dying to get a probation officer or a former probation officer on the podcast forever, and you're it. So welcome. Thank you so much for being here.
Thank you for inviting me.
May I call you Leslie?
Absolutely.
All right.
I wouldn't respond to anything else, probably.
Good. So I want to just jump right in, which is the pre-sentence. So for those of you who, people who are listening to this podcast probably know, but there's this whole thing in federal and most state jurisdictions where after a person pleads guilty or is convicted at trial, the probation department has the responsibility for writing a report that goes to the judge and helps the judge decide what a sentence is going to be for any individual client. And I will tell you, Leslie, when I started my practice in the Maricopa County, so before my days in federal practice, pre-sentence reports were done in most every case for felonies. And guess what? Lawyers didn't even attend. They just
And sentencings?
No, attend the pre-sentence interview.
Oh, the pre-sentence interview. Oh,
yeah. So there's this great, big, hopefully long interview that the probation officer has with the client to gather all this information. And it was the culture. And I don't know if it's still that way in Maricopa County, but we didn't even go to that. So whatever, just, have your client talk to the PO and hope it all goes well. Now, flash forward, I'm in federal practice and for most of my career, and that would be unheard of, I would hope, for a lawyer not to attend a client interview. But there are a lot of sort of I think maybe things that we lawyers tend to overlook when it comes to the pre-sentence process. And so that's where I want to start here, which is maybe best advice, do's and don'ts. When you and I talked about this, you said this is a topic that I hope I'm not giving anything up. You said it's a topic that gives me nightmares. So I guess I want to start there. Why, Leslie, does this topic give you nightmares?
It didn't used to give me nightmares. It gives me nightmares now because I now see, I was a sentencing guideline expert. I used to go to DC and I would train new officers in how to use the sentencing guidelines. So I am very familiar with the guidelines. And what gives me nightmares now is when attorneys AUSAs and judges are not familiar with the guidelines. They're largely familiar with them, but relevant conduct is still elusive, and attorneys really need to be conversant in the guidelines. But if they're not, because some just aren't, then they need to bring on an expert. And even though I'm a mitigation specialist, I always do guidelines work, always. And I'm able to find and talk about guidelines that are not commonly used.
Yeah.
So that's very frustrating.
And I will tell you, when I'm remembering my time, my first, year or so in federal practice, that was the scariest aspect, the most daunting aspect, because client pleads guilty, but unlike a lot of state jurisdictions, the plea's kind of open-ended. You never quite know for sure which guideline enhancements will apply and which won't. And the guidelines are huge. They're the size of a phone book, and there's a lot of esoteric guidelines that you don't see coming. They smack you in the face from left
Right.
field. They enhance the sentencing range way beyond what you probably told your client. Oh, if you plead guilty, this will probably be your range. And then all of
Right.
a sudden they're looking at, double that, and you go, sorry, I missed that. I mean, it happens all the time. So
Well,
yeah.
for example, there was a case I had talked to you about a while back. It was a case out of Nevada where my client, and post probation years, this was just in the last couple of years as a mitigation expert, he was a participant in a worldwide fraud, but he only caused about $900 in loss. So the government and even the CJA attorney who worked on the case agreed that he was responsible for the worldwide loss,
Oof.
even though he was just a spoke in the wheel, not even a spoke. He is severely schizophrenic. He was working out of his mother's basement with one computer. He has no friends. He didn't know anybody else involved in the scheme. And he was held accountable for over $5 million in loss.
Yeah.
So that is one of my nightmares, you
That's
know.
that's the relevant conduct you mentioned earlier,
Correct.
right? A
I
person
find
is
that it's
responsible for this little sliver, and all of a sudden they find themselves getting hit with the whole big nut for everybody else, which is usually because there's a conspiracy charge or something else.
correct.
Yeah.
Correct. You know, but you still have to show that it's jointly undertaken activity. So it's
Right.
one thing if it's reasonably foreseeable, but it has to be jointly undertaken.
Right.
So my guy in Brooklyn did not jointly undertake anything with this guy in Afghanistan, because it was literally countries throughout the world. There were hundreds of thousands of participants.
Well, what
So,
should have, in that instance, what should have a lawyer, what should have the lawyer or a lawyer do differently in to avoid that?
well, this case came to me after the plea agreement was reached. And he agreed in the plea agreement that his client was accountable for $5 million because he thought that's the way the guidelines worked.
Uh-huh. Yeah.
And I told him that is not the way the guidelines
Yeah.
work. But at that point, it was only a couple of months before sentencing.
Right.
He made the argument at sentencing, but I'm not sure he really believed in the argument, because then he ultimately said, Your Honor has the right to use the full $5 million he's accountable for, but he was not accountable for it. I mean, that's just one example, and my greatest
Yeah.
nightmare, probably.
Well, and it brings to mind a couple of, I guess, practice pointers from my point of view, which the first thing is you must know that once you cross that threshold and you've entered the plea, it's difficult, if not impossible, to go back and say,
That
oopsies,
is right.
let's unravel this. Let's work on
That is
this. No,
right.
you're
Right.
screwed. So if you haven't done your homework before you go in there and plead your client, you're in big trouble. The second, I think, thing is, besides the fact that maybe they didn't understand how the guidelines work, a lot of times lawyers get it, but they're a little timid to go back to the prosecutor and say, wait a minute, I'm not
Mhm.
agreeing to this. Dude's responsible for $900. This is ridiculous. And the third thing is, we'll back up what you're saying with some really solid mitigation. What lawyers don't understand is mitigation starts at the beginning of the case. And
Mhm.
my guess is, you mentioned your client's schizophrenic, he has all these issues. You know, my guess is if there was a thorough mitigation workup done before the plea is entered, so that all of these things could be presented to the prosecutor during plea negotiations,
Right.
that this poor guy might not have been in that mess. What did he get? Do you remember what his sentence was?
He got 48 months,
Yeah.
but he was looking at over 200 months.
Yeah.
So the judge completely considered my mitigation report.
Yeah.
But in my opinion, even if I worked in EDNY in Brooklyn my entire career, which you may realize is a unicorn. You know, Brooklyn is known for downward departures.
Yeah.
They're just known for that. Um, and if he had been sentenced in Brooklyn, he probably wouldn't have gotten any custody.
Hmm.
If for no other reason, I mean, he was actually being evaluated in Eastern District. I spoke to um, the, the people that had evaluated him, and they did not feel he should go to prison just knowing him and
Yeah.
knowing how severe his schizophrenia was. But here he was in Nevada, and he was lucky to get 48 months because he could have gotten 200 months.
Yeah.
And that would have been a miscarriage of justice. I mean, 48 months was a miscarriage.
Okay. So big tip number one, know your guidelines.
Right.
So, all right, well then, so let's talk about real practical advice for, so you pled the person, and now we're really in the pre-sentence phase, which is we're gearing up for the pre-sentence interview. We know there's going to be a draft pre-sentence report coming. We know that, well, hopefully we know that we have some input in what goes in that report.
Mhm.
Hopefully we know that the government has a lot of input about what goes in that report. So
Right.
what are some of the big, I guess, tips or pitfalls, that you would advise an attorney when to get ready for that? The interview.
Right. There's really not too much to do to prepare for the interview because you don't want to seem practiced. You want to come across as being sincere and answering questions on the spot. You don't want to sound rehearsed. In my opinion, it doesn't matter what you wear. It doesn't matter how you look. It's a matter of how you come across. So if you're going to be combative during an interview, I mean, probation officers, judges, lawyers are all human. If somebody's going to not cooperate with you, not give you the information you need, or start fighting during an interview, they may see things differently that may cast a shadow on everything you're saying. And it could, in fact, impact what goes in the pre-sentence report and what the recommendation ultimately says. Not because they're choosing to do that, but it's really hard to want to help somebody who is being combative, unfriendly, uncooperative during the pre-sentence process.
Yeah. Well, let's stick
So
with that word help, because I think there are lawyers or clients who may listen to this and say, I don't think that's the job of a probation officer writing a report to help a defendant in any way. What's your take on that? I mean, some probation officers say, well, I'm just a neutral reporter. I'm here to just pass information on to the court. And others would say, no, I want to make sure, that I'm getting it right for your client, so that, at least so that the judge has all of the pertinent, accurate information. So focus on that word help. Are they there to help?
they're really not there to help. But having said that, they often do help for one reason or another. It's not usually with regard to clients who are in custody, but sometimes you'll find that somebody needs assistance while they're out and you'll try to get them help, mental health treatment, drug treatment. But the essence of being a pre-sentence officer is being neutral and just presenting the facts. But having said that, if somebody is being uncooperative, it may be easy to forget about the good things.
Yeah.
I can't say that happens, but I do know, I mean, I was a supervisor most of my career. Even though a client's story, I think sometimes they would forget that they were actually mitigating factors. So they'd have to be prompted to put in mitigating factors. And it really varies. Now that I'm doing mitigation work, I see pre-sentence reports from all around the country, and there's a big difference going from one district to another.
Yeah.
So
Even little differences, which like in my home district of Arizona, the culture and practice is that when the final report comes, it comes with a detailed recommendation from the probation officer. But I
right.
know that in other districts, the recommendation is either not there at all or it's hidden from the defendant. So we don't exactly know what that is. But we'll get back to that because I want to go back to, okay, so you talked about the client. Client should be genuine, not combative,
Mhm.
honest, don't lie. There you go. There's our ethics credit for today. But what is the lawyer's role besides showing up for the pre-sentence interview and being by their side? Like, what is a lawyer supposed to be doing to kind of, I don't want to say grease the skids, but kind of make the process go smoothly from start to finish?
Well, you need to know your client. So you need to know if there are any issues that might come up. Should they discuss their prior criminal history? Should they discuss the offense? In Eastern District, and I'd say Southern District also, the inclination is not to discuss the offense during the pre-sentence interview, because you're probably not going to be helping yourself by doing that. In fact, I would recommend not ever discussing the offense itself, if at all possible, during the pre-sentence interview, because you can always send a statement later, something that you've thought about, and submit it. But I've never seen that. I've never seen the lack of a statement during a pre-sentence interview affect sentencing. But then again, my experience is mostly in Brooklyn.
Yeah.
So it was
Well,
it
and
was uncommon to discuss the actual offense during the pre-sentence interview.
right, right. And in my experiences, the bare minimum is you may not discuss the offense, but you discuss how you feel about the offense, which is to say you have to tick that box to make sure the writer understands you're accepting responsibility
Right, right.
because of
Or
those
even talk
magical
about how you
years.
became involved in the offense. That is the
Yeah,
more important thing.
yeah.
What led you to it? Were you using drugs and you needed to somehow support your drug addiction? Were you having financial problems at home? Do you have a sick child? That's the kind of thing that you really want to bring out.
Mhm.
Mitigation,
Yeah,
So I think going over that kind of information with your client ahead of time is probably helpful.
yeah,
Because there also may be things that you don't want your client to talk about. And they can say, your client has a right not to talk about any topic they don't want to talk about. They
right,
can say, I'm not answering that. They can do that.
right.
But then it's going to go in the pre-sentence report that they declined to answer.
Yeah,
So it's catch 22. So you're better off being prepared when you go in and knowing how, I guess, to spin things that might be uncomfortable,
yeah,
you know,
yeah,
because often the probation officer will have your prior record in front of them.
right,
And I would not offer anything, because sometimes the NCICs are not complete.
right,
Sometimes they don't include arrests that you might
right,
have. So you don't want to share information that they don't already know.
right.
So I would
Well,
say talking about the offense, talking about their mitigating factors,
yeah.
criminal history.
And not for, I mean, it's probably obvious, but that lawyering is leadership.
Mhm.
Leadership is preparation. So these are all things you have to work with your client in advance, in depth to prepare them. And so, you hit the nail on the head. The first thing they need to do is know their client. In other words, like mitigation isn't starting when you're sitting in the pre-sentence interview and the client says, I never got my high school diploma. And you go, I didn't know that. I should probably make a note of that, or these are, it's not the PO's job to develop mitigation. It's the lawyer's job, and you do mitigation, and when should a lawyer start working on mitigation?
Mhm. I say the day they meet their client,
The day they meet their client.
the day they
Exactly.
meet their client.
And we talk about this all the time on the podcast because that is, the client's getting sentenced for something. Sorry, especially in the federal system. That's how this works. Just look at the numbers. 95, 6, 7, 8% of every single client charge is going to end up in front of a judge for sentencing. So why on earth would you wait until the end to prepare for the most important day of your client's life? So hopefully by the time you've gotten to the pre-sentence interview, you lawyer know all this stuff and you've been able to sit with the client and say, all right, listen, we're not going to talk about this.
Mhm.
We do need to make sure that this is effectively conveyed to the PO who's writing the report. What I will do is, spend, I hope every lawyer does this, but spend some time, maybe it's 20 minutes, maybe it's an hour, maybe it's an afternoon, depending on the case, but just sitting down going, okay, this is what it's going to be like in that room. These are the kinds of questions that are going to be asked. The most important thing is to be honest. Don't lie about anything. They probably have the record. A lot of times they're just testing you to see if you're getting bullshitting them, right?
Mhm.
And if you don't guess, if you don't know the answer, say you don't know or you don't remember.
That's
And
correct.
I say I'm here to listen. I'm gonna not talk that much, but there may be times when I have to kind of jump in and say, I really don't want you to answer that question. And if I do that, that's okay. You don't have to answer the question. And the PO hopefully knows that it's the lawyer's fault, not yours, that I'm trying to control the
Right.
narrative. And then the question about the offense and everything else, yeah, no, I say towards the end or whenever it's going to be, the PO is going to ask you about the offense. If for whatever reason we don't want to get into the details about the offense, they have a factual basis that you agreed to in the plea agreement.
Mhm.
So I will usually just tell the PO we'd like to stick to the factual basis. He agreed to that in his plea hearing under oath. He doesn't have any qualms with that, and that's as much as he needs to say about the offense. But then I will tell them, make sure they know that A, how you feel about it, and B, what you're going to do to make it right, and ensure that it's not going to happen again.
Mhm.
I want you to convey to the PO that you've given some serious consideration to what you have done and how you're going to make it right.
Mhm.
And make sure they know that you've thought about it and that you're committed to doing that, and that goes a long way.
Right. And yeah, and that goes toward remorse, totally.
Yes.
And they're more likely to connect with your client if they do talk about their remorse, because if I mean, this doesn't happen very much in my experience because clients are very nervous during a pre-sentence interview. They
Yes.
just are, because they don't know what to expect. They don't know what it all means, even though you may have told them,
Yeah.
so, and
Well,
practice.
and hats off to a lot of POs that I work with who I want to say by and large, awesome group. I mean, I really do find them super caring and super thorough and wanting to do the right thing all around. But the ones that are the best that are the ones that recognize how damn nervous our client is and who show them some
Mhm.
basic like humanity. Maybe it's a joke, maybe it's a smile, maybe it's a if kind word, some
Mhm.
empathy for a situation, whatever it is. But POs need to know how important that is and really how far that goes to help a client through a really, really hard time.
Mhm.
Well, so I want to talk to you about, let's talk about the offense conduct. So
Mhm.
it is important, especially in cases where you don't have an excuse. So it's not about excuse, but you have sort of context or an explanation, like you mentioned earlier, like, how did I find myself in this trouble? And the lawyer really wants control over that narrative because they don't want it to come off the wrong way, like they're not minimizing or, blaming somebody else or something else. And so a lot of times the lawyer is not really going to be super excited about having their client speak extemporaneously in
Right.
that nervous environment of the interview. So, what are some ways that a lawyer can convey those important facts about the case and the client or help their client convey it in a way? Is it something we can do in writing later? Does it matter how we do it? Does it matter that it comes from the lawyer and not the client? Is it better to have it in the client's own words? Like what do you find most effective?
I think in the client's own words is much better because I've seen both. I've seen the attorneys write it in sort of a legalese, but it doesn't, it's more meaningful when it comes right from the client. But also, during the pre-sentence interview, there might be surprises. There might be surprise questions you weren't ready for. It happens. And it might be something your client wasn't ready for. Don't hesitate to say, can I take a minute with my client? For whatever reason, you have a right to talk to your client privately during the course of the interview. They may not always be receptive, but it's worth a shot. At least maybe try to frame what the response is going to be, or to try and avoid some pitfalls. But I personally don't think it matters. I know I saw a report recently. I had a client, I think it was not New Jersey or New York, but they were required to speak about the offense during the pre-sentence interview in order to get acceptance of responsibility. And so the pre-sentence officer had a list of questions, specific questions. It wasn't generic things like, did you commit this crime? Yes. Okay, that's good. It was, how many drugs? Where did you get the drugs? And it was this whole litany of things that I was kind of stunned to hear, because I've never heard that before. But they were not going to give acceptance unless they got answers, satisfactory answers to all those questions.
Interesting.
I
That's
can't.
crazy. I don't think I've encountered that either. My conspiratorial mind says somebody put a bug in their ear and asked them to do that, and maybe the government. But I would say if I'm the lawyer in that room, don't be shy, lawyers. Shut that down. And you
Mhm.
say there's no, you know, maybe if it's a safety valve and they have to proffer about the offense, that's another story, but there's no good reason a PO should feel they have the right to grill them down on on the nitty-gritty of those facts. It's not just your right, it's your obligation to shut that down. And
Mhm.
then if the judge has a problem with it, then you deal with it. But that's crazy.
Right.
And by the way, a story comes to mind because these POs are generally very well prepared, and I'll give you a great example. When I was a federal defender, my client had pled guilty, but it was very reluctant to plead guilty. So we knew that acceptance of responsibility was going to be a touchy subject because he really did have a good defense at trial, and he probably could have gone to trial, but at the end of the day, you know how it goes. The risk is so great and they're offered such a sweetheart plea that they say, all right, I
Mhm.
guess I'll just take the path of least resistance. And so, you know, had to prepare the client very delicately for acceptance of responsibility in the interview, and he did okay. And the PO pulled out a piece of paper. She goes, well, it's very interesting you say that because I was on your social media and you wrote, quote, pleading guilty in this case was the worst mistake I have ever made in my entire life. How do you reconcile those two things? It's like,
Well,
oh, well, on the subject of surprises coming out at the plea hearing, that's one of
mhm.
those points a lawyer who loves control basically has a heart attack on the spot. So yeah, you never know
Well,
what's going to come out of left field in those interviews.
but there's different ways of interpreting that. If he went on to say, it's the worst thing I ever did because I'm innocent, well, that's a whole other matter.
Right.
But it can be the worst thing that's happened in somebody's life, pleading guilty to anything.
Yes.
It's a conviction. So I guess
Well,
you could try to spin it, but also they don't want their family knowing that they're guilty either. Maybe they want to portray themselves as innocent to family and friends.
right, right. That happens a lot. And
Hmm.
thankfully, the pre-sentence report is not going to make it into the public record. That is one good aspect of this, right? So make sure your client knows that because that might give them a little more security to speak freely and not worry that the whole world's going to read everything that's said in there.
Right. I mean, the only caveat to that is, the Bureau of Prisons is not supposed to allow you to possess your pre-sentence report in custody, but it happens. And
Yeah.
if you're cooperating, or if there are other clients involved in the case, they're going to ask to see your pre-sentence report,
Mm-hmm.
because you can be able to tell from looking at a pre-sentence report if somebody's cooperating.
Right.
So, you know, I mean, that's something that definitely needs to be considered, because I've had numerous clients ask for copies of their pre-sentence report because
Mm-hmm.
co-defendants are demanding it.
Right.
Um,
Yeah, that is a thing. And they want to see your charges and everything else.
mhm.
So let's stick with conveying information to the pre-sentence writer. But now I want to flip the script and talk about what are the ways that the government, either the prosecutor or the case agent, gets to provide their version of the facts of the case to the PO?
And I can only speak about Brooklyn. I can
Okay.
sort of speak about Southern District of New York because it's very different. So in Southern District of New York, the practice has always been and still is that the AUSA will write the offense narrative and provide it to probation, and they'll just copy it and paste it into the report. That's how it goes. And there's very little independent assessment for the guidelines. That drives me crazy. It always has, because in Brooklyn, the government never did that for us. They would provide the complaint, they would provide indictments, you know, they would provide the file of various reports, but we would interview agents. I know that drives you crazy, but it's really the only way. So, because when you get it, what I've seen, but you got to get it
That kills
somewhere.
me.
I know. But if
What
you
would
get it
you
from the
interview the
government,
agents for? Like, you've got a summary of the case from the prosecutor. What do the agents give you?
just to see if there's anything else, because you'd be surprised how many agents are actually, compassionate and actually feel for your client.
You're right. I would
In
be
fact, it's
surprised.
more often than not. So,
Really?
so when I first started at probation, the Gambino crime family was being prosecuted in Eastern District of New York.
Hmm.
So I had one of the capos in the Gambino crime family. The government was trying to use all these cross references and all this conduct and murders, but it was what was it? It was a bid rigging offense, I think. And they wanted all this other conduct in there. But when I spoke to the case agents, they said, oh no, they had nothing to do with that. Like they were very focused almost entirely, like in my span of my entire career, on the facts, because that's just how they're trained, is to talk about how much was seized, who talked to who. It's more factual. But if you get it from the government, they give you a story, and the story is their version of the offense, their version of what these facts might have meant. And you don't want their version in there because their version is often wrong.
Interesting.
So
Interesting.
you more likely get the accurate facts of the case, because if there's a Fatigo hearing, agents have to testify to it. So let's say a case agent tells
Tell our
me,
audience what a Fatigo hearing is.
thank you for that. A Fatigo hearing is when you're challenging relevant conduct, facts of the case. So you're going to have a hearing to judge the validity of those facts, to see whether or not the court can consider them. It doesn't even happen. I haven't seen that many Fatigo hearings in the course of my lifetime, but it happens and it's a threat. So if an agent who would be testifying at the Fatigo hearing gives you incorrect information or false information, then they might be perjuring themselves at a Fatigo hearing. So they have arguably more to lose by giving you something that's untrue. But other than those two sources, I mean, other than the government and the case agents, there's really no other source unless you go out there and investigate the crime yourself. And there's just no time to do that. But at least in Eastern District, we would invite the defense attorneys to give their version of the offense. So it didn't happen very often. I mean, very often it was sort of intermingled in the acceptance of responsibility statement,
Yeah.
so that's really
Right.
where that you usually would be.
Well, that's sad. If you're given the opportunity to present your version of the facts, why wouldn't you take it, defense lawyers? This I always say is just about competing narrative. And if you're just gonna
Right.
roll over and accept the government's version, okay, I guess. But you're missing an opportunity. But I'll go back to the FBI thing because my
Yeah.
my initial instinct is to cringe. And I guess I'm thinking to myself, where is that emotion coming from?
Mhm.
And is it coming from an assumption that I'm making that a law enforcement, an FBI agent, a case agent is generally going to just trash your client and I should be scared about it? And you're saying, no, that's not necessarily true at all. But I think the backup emotion for me is this helpless feeling that I don't know where the kind of foundation of the work that I do is to be able to confront and challenge, refute, rebut the evidence. In other words, that's your narrative. Great. Here's my narrative, and here's the juice I have to back it up. But if I don't know, like for all I know, FBI agents have given information in 1,000 pre-sentence interviews that I've done over the years.
Mhm.
And I've never once read in the report, I spoke to FBI agent so and they said X, Y, and Z. No, it just says offense conduct and
Mhm.
then an explanation of the offense conduct. I don't know where the information came from.
Right.
And if I don't know who's saying it, how do I know if it's valid and how do I know how to challenge that?
Well, then you need to ask what the source is. The source really should be in there. So if they've spoken to a case agent, in Brooklyn, you had to talk to the case agent and you had to note it in your report. It had to be there. But like I mentioned, in Southern District of New York, they just get a narrative from the government. And that narrative talks about sentencing enhancements, which may not be correct.
You're right.
And that drives me insane because very often there are mistakes made in the calculation. But
Yeah.
once the government has made that assessment, then probation accepts it. And then it goes to the judge. And then the judge says, well, the government said this is true. Probation said it's true. So it must be true.
Mm-hmm. Do you
So,
do in your district, did the defense get the copy of the government's case summary with those calculations and all that information? Were they allowed to have it and see it?
from probation, you mean?
Well, so the government writes up a whole big schmear about the offense conduct and these are the enhancements and everything else and gives it to probation. Does defense get a copy of that? So
Well,
can they
that's
see
not
it
in
too?
Brooklyn. That didn't
Okay.
happen in Brooklyn.
Okay.
So it rarely, okay, I can't say it never did, but sometimes on huge, complicated financial cases, they would write it.
Mm-hmm.
Um, Usually at the request of the officer who didn't have
Yeah.
any idea what the case was about.
Right.
But I really can't say what they do in Southern District.
Yeah.
Uh, I I only know that the AUSAs there know that as part of the process, they have to write the offense conduct.
Gotcha.
So, and
All right.
that's always been something that we talked about in Brooklyn because all the officers I worked with, all the officers I supervised thought that was wrong. Because you can't really be an independent arbiter of the facts if the government has already done that for you. And the
Mm-hmm.
government's a little biased,
You
I'd
think?
say. Not in every case, but I would say in
Yeah.
most cases, they're a little
Yeah.
biased.
Well,
But
it's not.
can I tell you this though?
Yeah.
So now that I'm doing mitigation work, I love working with former AUSAs because they know all the tricks. They know what the government's going to try and do. And they throw their hearts and soul into being defense attorneys.
Hmm. Well,
Right.
that's good. That's good to know. Definitely encountered that with some former AUSAs. I've had one or two on the podcast, but I've also encountered, unfortunately, the opposite, which is they can't get out of their prosecutorial mindset and they
Yeah.
have a really hard time connecting with human beings and doing doing the work. So, but I think
Right.
maybe your sample rate may be
Huge,
biased
probably.
because they have the wherewithal to know they need you. In other
Mhm.
words, if they've got a mitigation specialist, you already know right there that they get it and they're taking that massive part of this case
Mhm.
responsibility very seriously. So, I'm glad to hear that. There's another aspect, and I've been talking about this on the podcast a lot too, and I'm probably getting myself in trouble, and I don't like to run anybody down, but we have talked about this on the podcast. There's this cottage industry of what we call prison consultants or
I
prison
knew this was
fixers.
coming. Yes,
Okay.
I
And
know.
we haven't talked about this, so I don't know what your take is, but here's
Mhm.
my take. Prison consultants can be great for various purposes, but the main purpose that I want a prison consultant for is to help me with prison issues, which is, what is mitigation about how harsh their sentence will be because they have special needs, or what is the right facility to be placed? How can I counsel a client to get
Mhm.
ready for prison and all that they're going to encounter in there and the subculture and the rules and the this and the that. There's a great place for those people. And a lot, and there's two classes of those consultants. One are people whose expertise comes from the fact that they've worked in the system. They've been
Mhm.
wardens in facilities like Maureen Baird, Jan
Mhm.
Purdue. These people I use all the time. I love them.
Right, right.
And then there are some whose expertise comes from the fact that they've been inmates in those facilities.
Mhm.
And some of those folks are awesome too. I have Walt Pablo on my podcast all the time.
Right.
But where I start to get very, very scared is they start to reverse engineer the advice. Basically, they're not just talking about prison. They're talking about now case things. Specifically, in our context, I'm going to be able to prepare you for your pre-sentence interview in a way that your lawyer is not. I'm going to get you ready and help you tell your story and help you present yourself in the very best light so that you can get the best pre-sentence report. And they'll charge high dollar fees to do that work and help them write out their story and all this other stuff. And it has little to do with the prison aspect and everything to do with the lane that the lawyers or mitigation specialists are supposed to be driving in. So I don't know. What's your take on the whole thing?
Well, I've had a couple of cases where the attorneys called in a prison expert for the sole purpose of that expert helping him to get into a certain facility. There's only one way that's going to happen, and that's if there's corruption, because you can't help somebody to get into a certain facility. So when somebody's sentenced, their pre-sentence report, their J&C goes down to Grand Prairie. In Grand Prairie, they evaluate everything and they take any piece of information they have. It could be from a newspaper, it could be from information about the trial. They can use any information in determining how you're going to be designated.
Yes.
So if somebody who was a former employee or never an employee promises to get somebody a particular facility,
Yeah.
that would mean that they have some kind of insider trading thing going on where there's a, I
Right.
can't even imagine how that would work.
Or they're at least representing that to be the case, and it's
Well, they
not.
are representing it to be the case. And I know that for a fact it's not true.
Yeah.
And my clients ask me what I think, and I say they cannot promise you a facility because they just can't.
Right. Right.
Because when the assessment's being made, they look at whether you're going to be safe, whether other inmates are going to be safe, are there any violence in your past they need to know about. So they want everybody to be safe, including their staff. So they're looking for the best fit. I know that, the LP has a bad rap for a lot of reasons, but they go to great lengths to try and make sure that you're in a proper facility.
Yeah.
So it bothers me because I know they charge a lot of money, and
Yeah.
to make the representation that they can get you into a certain facility,
Right.
it would have to be corruption.
Yeah.
There's no other way.
Well, and they had that deal with there was a group promising that they could get you into the RDAP, the Residential Drug Alcohol Program, and
Right.
paying money, and those folks got prosecuted because you can't. That was, the last time I talked about this on my podcast, I said the first thing you need to ask is, what are you promising me? And if
Mhm.
the answer isn't nothing, then run for the hills because nobody should be promising you anything ever. Not even a lawyer. A lawyer can't promise you a result, right? But that said, there are things that a good prison consultant can do to help the
Mhm.
lawyer get a good recommendation from the PO or the judge about placement, right?
But, I mean, yes. So they could tell you about programming. They could tell you to request Allenwood, one of my favorite places of all time. They could tell you to request these things, but even a judge can't make promises. A judge can recommend RDAP. A judge can recommend Danbury, but a judge can't. I mean, they don't listen. They don't have to listen to the judge. It's
Right,
just a recommendation.
right.
So if a
But it,
judge can't ensure it, how can a consultant on the outside ensure
yeah,
this is going to happen?
exactly. Yeah, if a federal judge, the most they can do is recommend, and the
Mhm.
BOP is free to disregard that. That's as much as you're going to get. That said, I do encourage lawyers to think about where might an ideal placement. You may not get it, but if you've done your homework about what would be the best place, then a judge will recommend that in my experience.
Mhm.
Again, doesn't mean you're going to get it, but a judge will recommend it.
Mhm.
And there are a lot of resources to find out what programming various facilities have and everything else. I'm curious, why is Allenwood your favorite?
Well, I've been there, but I like Allenwood because they have a lot of programming. You know, they have more programming than a lot of other facilities, maybe because it's a big complex, so they just have more to offer there. So I'm a proponent of Allenwood. However, most of my clients are from Brooklyn, Queens, Bronx, and Allenwood is in the middle of nowhere. It's down the road from Lewisburg, if that's something that interests you, but you don't really want to be close to Lewisburg if you can help it.
Yeah,
It's a
so I've
beautiful place, but
heard.
you don't want to go.
I've heard. All right, so let's keep going with this. So now we've got the interview done. Hopefully, we've presented everything in the way that we want. And the next
Mhm.
thing that comes back is called a draft pre-sentence report, which is a draft. It's appropriately named, but what it is an opportunity. Again, it's an opportunity, counsel, for you to review that draft with a fine-tooth comb and make sure every single thing in there is 1000% accurate. What happens when a lawyer falls down on the job when it comes to reviewing the draft pre-sentence report?
I am so glad you asked. The PSR follows your client for the rest of their lives potentially, because if there are any future arrests or prosecutions, they're probably going to ask for this report. So you want to make sure it's correct. Designations are based on it. Programming is based on it. Sometimes it affects visitation at the BOP. It has to be correct. I had a client recently whose page 2 showed that he was a non-resident of the United States, when in fact he was a citizen. And it was supposed to have been corrected at sentencing, but it was not. So he was sent to an administrative detention facility in Seattle because they were expecting to deport him, a US citizen. So you want to make sure that kind of stuff is correct.
Mhm.
Um,
And that's very hard to excuse my language, to unfuck that problem after it happened too, right?
yes,
So it's a lot of work, a lot of time, a lot of headache. This person's going from Seattle from New York. Is that
New
is that what
York,
yeah. So
correct,
he's
New
flown
York.
all the way across the country because they
Mhm.
think he's not a citizen and he is. And that whole mess could have been prevented by a careful reading and correction of the report.
Right.
Do you know
Well,
how long it took to fix that problem?
it's well, I can tell you because I had to fix it. So the problem is I'm not an attorney, and his attorney fled the coop day after sentence, which was very unfortunate.
Yeah.
So I found out that my client contacted me through links to tell me that that's what the PSR still said.
Hmm.
But in order to get it changed, I had to have an attorney appointed to him. They had to request a hearing. Months passed. Then they didn't send the report to the BOP. I had to ask the government to send the new pre-sentence report to the BOP. And even though the BOP received the report, he's still sitting there.
Hmm.
And it's going to be 2 years in August,
Oh, my
still sitting
goodness.
there. So he wasn't allowed to
Wow, wow,
participate
wow.
in programming because of his alleged status.
Which means
Um,
he's not getting all the FSA credits probably he's entitled to because he's not programming.
exactly. Exactly. I mean, he
Oof.
should be programming now, but Seattle is the worst.
Yeah.
But
Wow, wow, wow.
you want to make sure it's correct for so many reasons.
Yeah.
So the problem
Medical,
I
mental
had,
health.
yes, right. So for example, his same client, his pre-sentence report didn't mention his schizophrenia, even though pretrial had him attending mental health services, and they had all these reports saying he was schizophrenic, and didn't make it to PSR at all. So the judge had ordered that my report be attached to the PSR, but it wasn't. Probation never attached it. So the BOP didn't even know he was schizophrenic. They didn't know he was on medication. He had another client I had open warrants. They weren't really open, but the PSR said they were open. And because the PSR said they were open, he couldn't go to a camp.
Wow.
So
Yeah.
because they
Yeah.
assumed he had detainers, which he didn't. And this has happened multiple times.
Yeah.
So detainers, open warrants must all be closed.
Yeah.
But you
These
want to
are
make
all
sure.
things these are afterthought. These are not even afterthoughts. They're just ignored at so many levels by
Right.
probably very well-meaning attorneys who just don't know any better.
Another thing I want to mention, if there's any violence indicated in the offense narrative, or really anywhere in the report, that's going to affect your client's designation. It could be violence in the offense narrative, violence in the personal history section, in his criminal history, and that will determine where he or she goes. It will not be a camp. It will not be a less secure facility. It'll be a more secure facility because of the violent aspect. But if there's a chance you can get the violence out of the report, I mean, it has to be like redacted. That can't ever go to the BOP if you want that to not impact his designation.
Yeah.
And that happens mostly in the offense narrative, where they talk about alleged violence, then you show that it's not correct. That's got to come out. So,
Yep.
because if it remains connected to your client forever, and it will affect everything about their designation, programming, maybe even their release.
All right. So then you get this draft. You not only are making sure it's accurate, but you have the opportunity to file objections, formal objections to say, I don't agree with what's in here. And a lot of times the lawyers focus on just the guideline calculation. That's probably the most important objections you could file because that is the jumping off point to determine sentencing. But there are other things like maybe it's little, maybe it's not. But one thing that I routinely object to on principle alone is if there's a section in that report called other criminal conduct. And it's really just a list of other contacts that a client has had with law enforcement in their life. And maybe it's an arrest, but was never a charge and obviously no conviction. And it always just irks me that it's labeled other criminal conduct. And I say, well, there is this little thing called the presumption of innocence, which means you're not guilty of anything. You haven't committed a crime. So why are you calling that criminal conduct? Because you had law enforcement conduct. And it's to paint a picture that you're a ne'er-do-well and you lead a life of crime, and it's just dirt. It's just dirt. And in my opinion, it has no business being in the report, and certainly no business being called other criminal conduct. And I object to it all the time. I lose every time, but I still think it's worth making the point.
Well, you shouldn't lose, though, because it's not the proper place for it. So when you're looking at the pre-sentence format, there's also a section called other arrests. So if you've had criminal conduct that resulted in an arrest, but it was dismissed, you want that in there because you want to make sure the BOP designation sees that you arrested and it was dismissed.
Yeah. I'm not sure they distinguish those in my recollection. Well, maybe that's good to know. That's good to know. Maybe they stopped doing that. Maybe I was complaining so much they changed it. No. Anyway, but here's a thing though on the flip side. Just because you can object to every little thing doesn't mean you should. I've seen lawyers that object to say, my client's sister's name is spelled with 2 L's. You know, I don't know if this is the culture where you practice, but in my jurisdiction, it's pick up the phone or send an email to the probation officer and say, hey, Sally, just want to let you know my client's sister's name is Yesenia, with a Y and whatever, and my experience is the POs are very grateful that you can do those little things very informally and not have to, because every time you write an objection, you have to, PO has to respond to those in writing on a back page of the report. It's just making more work for them.
Right.
So a little love goes a long way with that kind of stuff. Is that right? Is that your experience?
If you can pick up the phone and call about that kind of stuff, you should. My experience is that attorneys more often than not only focus on the guidelines. They don't focus at all. They don't even mention things like misspellings or small errors like that because they decide that it's not important, but it can be important. So even with spellings of names, if the BOP looks at the report and says, oh, but you're not listed here as a family member, you want to make sure it's correct. Because the document is there forever, you want it as correct as possible. I say if you have to err on the side of too many objections, go for it. And if you can call about some things, fine. But it also shows a pattern. So if you go through a report, a PSR, and you see a lot of mistakes, it shows a pattern of maybe, carelessness. So that might even support any other things in the offense narrative or the calculations, not that I advocate that per se, but sometimes you might want to show a pattern of carelessness by the USPO.
Yep. Yep. And I think maybe the last advice on objections is, and we started with this, which is know your guidelines. Because
Mhm.
even if there's not a guideline that's coming way out of left field to beat your client into oblivion, the guidelines change all the time. And
Right.
it's hard for us to keep up with them. And POs are not perfect. And if you don't know the changes that not only that have just gone into effect, that maybe are going to go into effect. So we had this with the 0 point offender
Mhm.
thing. It
Mhm.
was approved in, I don't know, May or something, but it's not
Right.
going to be official until November. But lawyers needed to know that and start making those essentially objections right then and there to say, look, we know this is the law. Why don't you just give it to us?
Right. Well, it went
Yeah.
to effect November 1st, and that didn't seem to make a difference. Every case I've had since then, every one has been entitled to the 0 point offender reduction.
Yeah.
None of them have been given it by probation. None of them.
Wow.
Granted, the draft PSR went out before November 1st,
Yeah.
but then it was their obligation after November 1st to amend the reports. Never
Yeah.
happened.
Yeah.
Who objected? Me. Because even the attorneys I worked with had no idea what I was talking about,
Yeah.
you
Yeah, no,
know?
I found that too. It's very listen, it's hard to keep up on everything, and that's our job. So, sometimes we have to educate them. And on that note, I've done like 6,000 episodes on the guidelines and the changes and everything else. So I could put some of those links in the show notes. Hopefully by now attorneys know about 0 point offender, but there have been criminal history point adjustments, all that stuff. And the big talk now is relevant conduct and acquitted conduct. So
Right,
there
right.
could be some seismic shifts, more seismic, at least we hope so down the road. I think I only have one more question. Just and then I just kind of want to throw it to you. What did I miss? But this idea of the PO's influence on the judge above and beyond the four walls of the written report.
Mhm.
So, like I said, in my jurisdiction, it'll just be an addendum with their recommendation. This is what I think as the PO his sentence should be, and these are the reasons why. They call it the rationale or whatever, the reasons. And I love that because I can see it
Mhm.
and address it. And if I don't think the rationale is sound, I can make my case to the judge about why that's not. And their recommendation is not the be all end all, but it matters, right? But then there are other jurisdictions that I've seen where it's written, but it's secret and I don't get it.
Mhm.
And I don't know what's in there and I can't attack it. I'm disadvantaged. That is fundamentally wrong, in my opinion. Absolutely wrong. Our job is to be able to confront the evidence against our client. Hide the ball shouldn't exist. And it
Right.
exists all the time in federal court in all different facets. And one of the things that has killed me about federal practice since the day I set foot into federal court is hide the ball with discovery. It's hide the ball with witnesses. It's hide the ball with grand jury transcripts. It's always, always, always hide the ball, and it's bullshit. I'm sorry. It's not right. But can I say bullshit on this podcast? Oh, wait, it's my podcast. I can say whatever I want. And I'm not here to piss any judges off. I just need to make sure they understand that is not fair. It puts us at a disadvantage. And in a system that purports to be fair and equal justice for all, you want each side to have equal advantage.
Mhm.
And one of the things that really scares the hell out of me is when I'm sitting in court on the day of sentencing with my client by my side, and I see the PO in their nice suit, very friendly person, wave, hey, how you doing? And they're on their way into the back to the judge's chambers because the judge wants to sit with them in
Yep.
private and talk about the case before
The day of
she,
sentence?
yes.
Wow.
Now, clearly that doesn't happen in your
No.
jurisdiction. It definitely happens in other places. The last time I saw it with my own two eyes was in Michigan, Eastern District. I was at Detroit, Eastern District. It was in Detroit and it happened. And the PO spent a good half hour or more in the back in chambers. And I'm sitting there the whole time going, I don't know what's going on, what they're saying, what information they're giving. Is it true? Is it accurate? Have I addressed it? Have I been able to anticipate in my pleading? Blah, blah, blah. Like, I don't know. And I'll never know. And
Mm.
I am, so I guess I'm just like, what is, what's your take on, first of all, what does the PO's sway? What is the PO's influence and sway with the judge? And have you had these experiences where there's a little secret side, little hide the ball situation happening?
Well, they work for the court. So we do whatever the court asks us to do. Even though I haven't seen what you're suggesting, because it's just inconsiderate. Why would you do that in the middle of a sentencing proceeding? They have called
Well,
on
in
occasion,
fairness, it was before this sentencing proceeding started, but
but it was, yeah, but you were sitting there waiting.
I
It's
was
even
waiting.
worse.
Yes.
But we have had judges call us and ask our opinions on things.
Mhm.
Usually it's though for clarification because they don't understand the guidelines, or they have a huge multi-defendant case and they're trying to put it, this one client in perspective to all the rest. And it's just harder sometimes. They just want to talk to somebody about it. But we had one judge actually summon one of my officers to his bat cave. So he actually called it a bat cave where he would sit and talk to them about it. But I don't really even know what they discussed, but you're really a part of his staff. So I don't know that that's ever going to change
Mm.
because probation works for the court. But
Wow.
anything the judge does at sentencing is on the record. He's got to explain if he goes up or down. Doesn't have to explain where the sentence is in the guidelines or why in the guideline range. But
But
it should be based
the
on that,
judge knows how to choose their words carefully in that explanation, and
right?
it will never reference, well, I spoke to the PO off the record and they told me your client, did X, Y, and Z and is an unrepentant, you know, sack of garbage. That's why I'm sentencing him to this case, you
Oh,
know.
well, that
I
should
mean,
be in the
it
report.
could go both ways though. I mean, sometimes, like you said about the FBI agent, maybe feels kind of bad for this person and says, Judge, I spent some time with this person. They're
That happens
genuinely
a lot.
remorseful, or they're really working I think they're sincere about getting their shit together. And, if anyone deserves a break, it's probably this dude.
Right.
But what are the three things that lawyers need more than anything to do their job? One is credibility, right? And the other is connection, not just the lawyer connecting with the judge, but the client connecting with the decision makers. And the most important one is we thrive, we crave is control.
Mhm.
The three C's I call them. And when I have no understanding of what's being communicated to the judge by the PO, or no understanding of what's being communicated to the PO by the FBI agent, I lose
Mhm.
my shit because I need control. It kills me. So I don't know if there's any good solution to it, but I think lawyers, I would tread lightly by saying, Judge, I need you not to meet with them or anything, but I don't think there's anything wrong with asking the government or the PO for the information that been provided to, make their report. You may not get it, but I think you're within your rights to ask for it. So,
You can certainly ask the judge to release that. That happened all the time.
yeah,
To release any kind of documents the PSR is based on.
yeah,
The judge can say no, but
yeah.
the judge more often than not will say yes.
One judge in my district had an interesting practice where during the sentencing, I don't think he would meet with the PO off out
Mhm.
in chambers, but they'd have the PO. Most judges do have the PO sit in the witness box there, you
Mhm.
know. But his practice was always to give the PO the last word. He'd look over and say, "And what do you think?" And he already knows that has their recommendation written, but
Mhm.
all of the information that was presented in the hearing and everything else, he would look at them and just wanted, I guess, want to make sure that they didn't change their mind after hearing something new in court or something else. And I have never seen another judge do that, but I always thought it was interesting.
Mhm.
And, the one instance that stuck out in my mind was when we had played a sentencing video and we had played it in court. And the PO actually was filling in for the report writer. And he came in at the beginning of the hearing and said to counsel, super nice guy, he's like, I, I'm just here as a potted plant, basically, nothing I can do. So don't look at me. I'm just here. But they saw the video and everything else, and the judge leaned over at the end and said, "What do you think?" And he goes, if I were in the situation that this guy was in, I probably would have done the same thing. So I understand. And it made all the difference in the world what
Mhm.
that PO said on the spot in the hearing. I've never seen it happen since, but
Mhm.
miracles do happen once in a while.
And
What
it
did
really
I
depends on
forget?
the judge.
What's that?
It really depends on the judge too.
Yes, it does. It does. This is like, I always say, this is like playing the lottery. Who's your judge? Who's your prosecutor? There's so many variables that can determine whether you get a good outcome or a not so good outcome, which is random and weird and sad in its own way. But we do the best we can. We talked about a lot. What did I forget? Or what did you come ready to?
Oh, I don't know. I could have talked about each one of the topics you mentioned for
Yes.
the entire time.
Well, we can always do this again, Leslie.
Mhm.
We know part two, but I think this was a very, very, very good start. And I would tell all of my listeners, do you just mostly work in like greater New York area, or is your practice national?
I've had cases in California, Chicago,
Okay.
Nevada, but it's usually because I've been referred by somebody in New York.
Okay. Well, I
So,
wanted everybody to know, I mean, listen, guidelines expert, mitigation expert. It's a great, great knowledge base. And, I think lawyers need to be hiring people like you in their cases way more often. We just did a podcast where we're advocating for uniform mitigation standards in every
right.
non-capital case.
Mhm. Mhm.
So I would encourage anybody who is interested in talking to Leslie. I have your email, which is leslieSlockwood@gmail.com, and I'll put that in the show notes. I don't know if you have a website or any other information you want people to know about you,
It's
or
Leslie.S.
oh, did I not? I forgot one dot. Sorry. Leslie dot
Leslie
S
dot.
dot
Yeah,
Lockwood at
yeah,
gmail.com. Thank you.
I
Thank you.
know.
Thank you. Thank you. You got
I should have
two dots.
reconsidered that S, but
That's all good. It's all good. Um, well, thank you, Leslie. I'm so grateful that you came on, and I hope we talk again soon.
I hope so too.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.